You're watching a live feed right now in the Shawn Grate case out of Ohio. Joining me via Skype is death penalty expert Stephen Mulroy. Stephen, good to see you.
Good to see you as well.
So as we listen to the Shawn Grate case, one of the interesting things is the bifurcated nature of this case, in the sense that jurors are first going to have to determine whether he was guilty or innocent, and also these sexual motivation specifications. And then if they find him guilty of that, they move into whether or not he is guilty of sexually violent predator specifications. And if they find him guilty of that, then they move into sentencing. I guess my overall question is, how does this all play in terms of what he might ultimately be sentenced to, since this is a death penalty case?
Yes, well, this is a bit of an unusual provision in Ohio law, where there's a separate finding that the person has sexual predator status, which basically is a prediction that he will do this kind of thing again. That these types of crimes, sexual predator crimes, tend to be the type of crimes that if the person does it a few times, then they're going to keep doing it. So there's factors that the fact finder, either the jury or the judge, has to find beyond a reasonable doubt that the person is likely to commit these kinds of sexual predator offenses in the future, that they are in fact a sexual predator. If that finding is made, then it is much more likely that the person will get serious sentence like life imprisonment without the possibility of parole, or possibly the death penalty.
It's so far it's a disturbing case. I mean, really listening to the details of it. I mean, just before we cut in, they're talking about maggots that were found basically at the crime scene. So, Stephen, there's a lot to talk about in this case. I want you to stand by. We'll jump back in because there's a lot of gruesome details that we'll get into in a minute.
Sure.
So, Stephen, stand by. Let's jump back in. Again, this is a BCI expert. Let's listen in live to the Shawn Grate case. All right, everybody, they cut the audio for a minute. You were watching a live feed in the Shawn Grate case. That's a 41-year-old man right there. He's charged with 23 counts in this indictment. And the prosecution really laid out each of the charges. That was an interesting move to see that, how in the actual opening statement, they listed the facts and then applied them to the actual language of the law. You don't always see that. Now, he is charged in connection with the deaths of Elizabeth Griffith and Stacy Hicks, as well as the kidnapping and rape of an unnamed woman named Jane Doe. That's what they're calling her. And the reason police were ultimately called to the house was because that Doe was able to free herself, and she got on the phone, called 911, said what was happening. Police responded, and we've played that 911 phone call. You can hear it. It's pretty dramatic when they tell Mr. Grate to get down on the floor. I believe we still have with us, I just want to make sure, University of Memphis law professor Stephen Mulroy. Stephen, you still with us? Great, great. So again, we're talking about this case, and there's so many interesting specifications. How does the defense try to tell the jury, you know what, don't make up your mind immediately when you hear about the gruesome details of this case, and they are pretty gruesome. Have an open mind, don't prejudge our client, listen to everything. How do they do that?
It's a very tough thing to do, I think. In a case with the details as shocking and macabre as these are, you know, juries, they're not robots. Obviously, this is going to affect them. So I think it's a tough thing for the defense to do. I think the only thing you can do is to, you know, remind them that they swore an oath, that this is a very serious matter, literally of life and death, and that, you know, their duty under the law is to keep an open mind until all the evidence is in. You know, that's really up to the advocacy skills of competent defense counsel.
And how do you introduce the mitigating factors, in the sense that one of the interesting aspects of this case is the defense wants a little bit more time to study the brain, for lack of a better word, to study the brain of the defendant through a special kind of imaging. What do they hope to find? What do they hope to say, hey, jury, look at this. This explains more of what happened? Well,
I mean, obviously, I think that in a situation like this, where there is just such evidence and the details are as gruesome as you pointed out, insanity, diminished capacity, some sort of argument that the defendant isn't really legally responsible for the acts that he may have committed due to mental disease or defect of some kind. I mean, I think that's clearly where they'd have to be going with all of this.
And does that work, just saying, or does it also matter the exact type of disorder? Because one of the, Dr. John Fabian, who's somebody that the defense is working with, he listed a number of different diagnoses for this man.
Right.
Some of them seem to be more persuasive than others, but again,
Right.
what are you looking for as a defense attorney?
Typically, you're looking for some sort of official diagnosis of an actual recognized mental disease or defect by a recognized expert, which would either show that the defendant lacked the capacity to understand right from wrong, or what the nature of what he was doing, or that he lacked the ability to control himself. And unless you can show that, then you're not going to get off on an insanity plea. There are all types of mental diseases or defects that you could have that don't go to either of those criteria, and therefore wouldn't really be a defense. As a matter of fact, the insanity defense is rarely invoked, and when it is invoked, way more often than not, it is unsuccessful. Jurors tend to be somewhat skeptical about insanity defense arguments.
Yeah, it's easier said than done. All right. Room. We do not want to miss anything. Again, you're watching the Shawn Grate case.
Among yourselves, don't let anybody discuss it with you. Don't form any opinion or draw any conclusion at this point.
Well, I hope you didn't miss me. That was pretty quick. So they're going, I think the jury is leaving right now. We're back with Stephen Mulroy, University of Memphis law professor, talking about the Shawn Grate case. But while I have you, I'm really curious. We talked earlier about the Tex McIver case off air. And again, people are shocked by this verdict. They're shocked by it. They're trying to understand it. Mr. McIver's not guilty of murder, but he's guilty of felony murder? What does this mean?
Yeah, it can be confusing to the layman, I think. Almost all states have a rule of felony murder that you can be convicted of murder if you committed an underlying felony, and as a result of that underlying felony, someone got killed. So even if you didn't intend to kill, even if you didn't kill intentionally or knowingly or even recklessly, if you went into the liquor store with the intent to rob the liquor store at gunpoint, and as a result someone gets killed, you are guilty of murder because of that. So felony plus a killing equals murder.
So, in other words, the felony here is aggravated assault. Again, we're waiting to go back live in the Shawn Grate case, but we're talking about the McIver case while I have Mr. Mulroy, because it's really important to understand this. So again, Tex McIver was found guilty of aggravated assault. Does that mean that he wanted to hurt Diane, and as a result, when she died, he's guilty of that murder? Is that the way to understand it? And if that's the case, does that make sense? I mean, do we have evidence that he wanted to hurt her?
Well, so it was up to the jury to decide whether he intentionally pulled the trigger, as the prosecutor claimed, or the gun just went off accidentally, which is what the defendant claimed. This seems to be a compromise verdict, because you're correct. A conviction for aggravated assault means the jury found that he intentionally wanted to harm her, although not necessarily kill her. And then as a result of that felony, she ultimately died. This is a compromise verdict between jurors who might have been willing to buy the argument that the gun went off accidentally and jurors who said no, intending to kill her. What they did instead was say, well, he intended to harm her. And then under the felony murder rule, that leads to a felony plus a killing equals murder. What's unusual about this, though, is that that particular type of underlying felony, aggravated assault, usually doesn't trigger the felony murder rule. There are common law rules that say that, there has to be a robbery or a kidnapping or a burglary could trigger felony murder, but you don't just say some lower form of murder or assault could trigger murder, because then almost everything becomes murder, right? You get into a fight and you hit somebody, and then through some freak accident they die. Yeah. That suddenly becomes murder. So most state statutes spell out specifically which felonies can trigger the felony murder rule and which can't, and aggravated assault usually isn't one of them. The Georgia statute is very, very broad. It just says any felony, period, which I think makes it among the more strict of the state felony murder statutes.
I'll be the first to admit it. We were talking so much about murder that we kind of glossed over a little bit about the felony murder and the aggravated assault. We should have maybe focused a little bit more on it because we really thought the jury was going to have to decide, was this an intentional killing or was this involuntary manslaughter or was it an accident? That seemed to be the three options. Are you surprised they didn't go involuntary manslaughter?
It seems based on the evidence, they would have either gone with straight up intentional murder or they would have gone with involuntary manslaughter or maybe even excusing him. So I was surprised that they kind of met in the middle. But, you know, maybe I shouldn't have been surprised because jurors do this all the time. When they have people on the jury that have very, very different views, they sometimes come up with a compromise verdict and meet in the middle. It may not make the most sense, but it's what jurors decided together was the most fair way of resolving their differences.
I want a key point you just said, compromise. We know, if you've read anything about this case, some of the jurors after this verdict have said that there was a compromise. They were deadlocked yesterday. We thought that there was going to be a mistrial, a hung jury. How do you go from a deadlock to a short time after guilty of...
And that shows the efficacy of the so-called Allen jury charge, or what they sometimes call the dynamite jury charge, where a deadlocked jury is brought in and the judge reads a statement that says, you know, you have a duty to come to a conclusion. Everybody, I want you to re-examine your beliefs, you know, go back in there with an open mind and keep talking until you can come to a unanimous verdict. They really took that to heart. You know, jurors went back in and started from scratch and re-examined their own beliefs and biases and came up with what they admit is a compromise. There were people who were dead set on saying the gun just went off, it was an accident. People who were dead set on saying he did it intentionally, this is straight up murder. The way they decided to avoid being a hung jury was to, as we say, meet in the middle on aggravated assault, which Georgia triggers a felony murder conviction.
No way to predict it. No way to know. Always surprises here on Law and Crime. Stephen, stand by. What we're going to do right now is, again, as we talk about McIver this morning, because this verdict was so shocking, and we'll talk about it more later on today, I want to again focus back on the Shawn Grate case.
Yes.
As we were waiting to go back live in this case, our very own Rachel Stockman did a report about this case. Take a look. It gives you a summary about what to expect in this really, really horrific situation.
The trial of a suspected serial killer, 41-year-old Shawn Grate, is underway in Ashland, Ohio. Grate is accused of kidnapping and sexually assaulting a woman, and he's been charged in connection with the murders of 2 other women in an abandoned house. Grate was arrested when that woman he was holding captive was able to call 911 while he was asleep.
What's the problem? I've been abducted. Who abducted you? Shawn Grate. Where's she at now? Asleep.
In an opening statement, prosecutor Christopher Tunnell made it clear this case was not a whodunit.
The evidence will show beyond a reasonable doubt that this defendant was found asleep and naked in bed in a house that a terrified naked woman escaped from after being repeatedly assaulted and raped by this defendant. 2 decomposing bodies having been kidnapped and murdered by this defendant.
He also went into detail about the defendant's involvement in the murder of 2 women found inside that abandoned house.
Even as he gives multiple versions of his killing Elizabeth to detectives, and he admits to killing Elizabeth Griffith. What exactly happened to Elizabeth Griffith, we'll never know. It would seem that after Stacy bought the defendant a cup of coffee at BP, she gave him a ride back to his place on Covert Court. And once inside that house, she never left. Recall that officers in their initial sweep of the residence after forcing their way into the basement sensed something was terribly wrong downstairs from the smell. The stench of death was strong. And after Stacy was strangled, she was wrapped in a basement and taken down the basement steps.
The prosecutor summed up his opening statement by reiterating there is no doubt the defendant is guilty of these alleged heinous crimes.
The evidence will show this is not a whodunit case. The evidence will show that this defendant is guilty of all 23 counts as contained in the indictment, all specifications thereto, beyond a reasonable doubt.
The defense did not give an opening statement, at least not yet. Grate faces 23 counts, including aggravated murder and kidnapping. If convicted, he could face the death penalty. For the Law and Crime Network, this is Aaron Keller.
All right, everybody, that wasn't Rachel Stockman delivering that report. That was Aaron Keller. But again, gives you analysis about what we can expect in the Shawn Grate case. Before we bring in back Stephen Mulroy, I want to play for you the 911 phone call that was started by Jane Doe. Remember, she was the reason police were ultimately brought to that crime scene, that horrific scene where these two decomposed bodies were found. And it's because of her that we're at where we are today, in a courtroom trying to see what will happen to Mr. Grate. So let's play that really disturbing 911 phone call for you right now.
911, what is the address to your emergency? 4th Street, Laundromat. What's the problem? I've been abducted. Who abducted you? Shawn Grate. Where's she at now? Asleep. Where's she sleeping at? In the bedroom. Please hurry. Does he have a weapon? He's got a taser. Are you tied up now? Yeah, but I kind of freed myself. Are they on the way?
Yeah, we have officers we're sending.
Please send them up.
Hey, if you're worried, you don't have to talk. You can just set the phone down, okay? I just need to hear if the officer's find you or not.
Oh, shit, I woke him up.
You just set the phone down. Okay, can you get to the door where you can see out? Huh? Can you get out of the house?
Locked.
It's locked. Are you at the door?
Yeah, I am.
She's at the door.
Come on out. Hurry up. Get out of here. Where is he?
Bedroom sleeping.
Still sleeping?
Yeah.
Okay, they have her.
He's not armed.
He's unarmed?
Yeah.
All right. Right now. Do it. Don't do that.
All right, ladies and gentlemen, that was that really chilling 911 phone call from Jane Doe, where police were called to the residence. This covert house, again, this is really an unbelievable case when you listen to the details of it. And we want to talk a little bit more about it as they are on break right now. We expect the courtroom feed to come back any second. I want to bring back University of Memphis law professor and death penalty expert Stephen Mulroy. Okay, here's something that was an interesting aspect. The defense waived their opening argument yesterday, their opening statement, excuse me. Why? What do you think's going on?
That is an excellent question. That's an unusual move. I'm surprised that they did that. It might be that they think that the details are so horrific that there's really nothing to say until they can get into evidence that would mitigate about his mental disease or defect or something of that nature. But I've never heard of that happen before in any case that I've been following or been involved with. Usually every lawyer takes every opportunity they can to address the jury. So I'm probably as surprised as you are.
I've seen cases where they might say, you know what, we won't put it on now, we'll put it on later after the prosecution puts on their whole case. But again, after you heard, if I'm a juror, and I know the opening statements are not evidence, but man, is it good to listen to. It tells a story. And you listen to the details of what they're accusing Mr. Grate of. I would like to hear something from the defense, at least at the bare minimum. Have an open mind. Don't make a judgment. The beauty of our system is you're innocent until proven guilty, but we didn't hear any of that.
No, that is surprising, and the danger is that the narrative of the prosecution can get lost in the jurors' minds unless you rebut it fairly quickly. Now, you're right. I have heard of situations where the defense has said, we'll do our opening later on at the opening of our case and the conclusion of the prosecution's case in chief. But what I hadn't heard of was, and I don't know if this is what they did, saying we're waiving it at all. We're just going straight into the evidence without doing an opening later.
We covered a case here, a Donald Smith case. I mean, this case was horrible. It was about now he is a convicted child rapist and murderer. But during the trial for this, his team presented an opening statement. It was okay, not really great. And then throughout the rest of the case, they didn't cross-examine any witnesses, and they waived the right for a closing argument. They basically gave up and said, you know what, they might have had a conversation with their client, I'm sure, and said, you know what, we're not going to fight any of this. Why it went to trial, I don't really know. But I wonder if at some point, and maybe you see it during the course of a trial, the attorneys say, you know what, we're not going to do anything more. We're going to let this play out. We're going to let the state put on their case. I don't know. What do you think?
I suppose it's possible, but of course, then that raises the question of why wouldn't they just then plead?
Right.
Why didn't they just stop the trial?
I always wonder that too, and I've heard other people say, well, you know, the defendant, sometimes, I'm not saying it's this case, sometimes the defendant likes the spotlight, likes to be out there, have his name known, maybe is proud of what the deeds were that he's accused of or she is accused of. Not sure that's this case, but it is something to listen to. So what I want to do right now, Stephen, is we have some more testimony from yesterday that I want to play for you, and when we come back, Stephen and I will talk a little bit more about it. So here's some more testimony from the Shawn Grate case from yesterday.